The next case that is set for hearing this morning is Wells Fargo versus Catherine Russell. It's case number 29005. Both parties are represented by counsel. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. So just let me know at the beginning how much time you would like to reserve, and I'll keep track of that for you. These arguments are recorded, so please keep your voice up and remain at the podium. We've read the briefs and are ready to ready to proceed. Excuse me. You are, sir.
Good morning, Your Honor.
Good morning.
My name is William Behrens. I'm here on behalf of the Dan Law Firm and the appellant, Catherine Russell. May it please the court, I'd like to reserve 5 minutes of my time.
5 minutes.
For rebuttal. Your Honor, it's funny. I noticed in the prior case that he mentioned a sense of deja vu. Certainly that applies here as well. This case is before this court now for the 4th time. This is a 2011 foreclosure case that was remanded initially due to defects in the initial judgment order and a failure to address the priority and the amounts of liens. Subsequent to that remand, the plaintiff attempted to cure that defect through invoking Civil Rule 21 and adding a new party. And this is a party that had been disclosed in the preliminary judicial report. It was clear from the time the complaint was originally filed in 2011 that this was a valid lien holder, and they simply were never named as a defendant in the action. So the plaintiff happily, under Civil Rule 21, attempted to, or asked permission from the court to amend their complaint and add this new party. We opposed that motion. The court overruled our opposition. We then filed an answer to the amended complaint, which the appellee asked the court to strike, and the court granted that motion, striking our answer, essentially ruling that the initial foreclosure judgment as to my client remained valid, and that the new party, the addition of the new party subsequent to that judgment apparently had no impact. The case continued on through 2 more appeals, and it was remanded 2 more times due to ongoing defects in the priority, the amount of lien holders, and then in the third remand. I think this court really tees up the issue that is before it now very well in paragraph 13 of the court's opinion. At the time that the plaintiff moved for summary judgment on the amended complaint, let me take a step back. This court remanded this case after that third appeal because at that time the plaintiff had never moved for judgment on the amended complaint. They had entered into agreed orders to address the priority and the amount of liens, but they had never actually filed a dispositive motion as to that amended complaint. So this court sent it back down, and I think gave the trial court a very good roadmap to follow in paragraph 13, and unfortunately that roadmap wasn't followed, and that's why we are here today. Ultimately, the appellee moved for summary judgment on the amended complaint. We opposed that motion for summary judgment, and we asked the court at that time to address the issue of the fact that we were never given the opportunity to file an answer. We were never given the opportunity to conduct any discovery, and the trial court's decision in granting summary judgment was very odd, in that the court came back and said they will consider that a motion to reconsider the decision to strike our amended answer, that at this point had been filed 3 years ago, and considered our amended answer and entered judgment for the plaintiff appellee. The concern there is that we were never given any opportunity to conduct any discovery. We were never even aware that we were able to actively participate in the case because we were still relying upon the ruling from 3 years prior to striking our amended answer. So we have asserted 3 errors here. The first error is that the trial court erred by permitting the addition of the new party defendant under Civil Rule 21 subsequent to the initial judgment entry. And the reason why we believe that is an error is that under Civil Rule 21, the parties must show, or the plaintiff must show, inadvertence or mistake. And there can be no inadvertence or mistake here where they knew from prior to the filing of the complaint, it was disclosed in their own preliminary judicial report, that Fargo Constable was a necessary party. And so we don't think they ever met the standard that would have permitted them to add them under Civil Rule 21, regardless of the prior judgment or not.
That's an abuse of discretion standard on that assignment, would you agree?
We agree, Your Honor. The second issue, and quite frankly, I think the more thorny issue, is the court's decision at the time that it granted summary judgment on the amended complaint to say, we are reconsidering the striking of the answer, we will consider that answer, and we'll grant summary judgment anyways. Again, 3 years had passed in that time. The servicer had changed. The evidence that was presented in support of summary judgment on the amended complaint was an affidavit from an entirely new party, the employee of the servicer, who had changed in those 3 years. And the court's basis, part of the court's basis in granting summary judgment, was that we had no evidence to rebut, that they had met their initial burden under Civil Rule 56, and we could come forth with no evidence. The problem is we were never given any opportunity to procure that evidence. Again, we were relying upon, at every opportunity, the court had told us emphatically over and over again that we would not be given an opportunity. Our answer had been stricken, and it wasn't until judgment was granted that all of a sudden our answer to the amended complaint was considered. I think that creates a due process problem, but I think that it's a problem that this court doesn't have to reach if you find under that first assignment of error that they have a Civil Rule 21 problem. The third assignment of error that we've entered is probably the least likely to be dispositive here. But if this court finds that there are no issues under either of the first 2 assignments of error, the problem still arises that the motion for summary judgment was supported by the affidavit of an employee of the servicer for SPS. And at that point, that servicer was the successor to the previous servicer, App.No, and the affiant was relying upon all of Aquin's business records in the majority of the statements made in her affidavit. And the problem is that as an employee of SPS Loan Servicing, that affiant had absolutely no knowledge of the circumstances of Aquin's preparation of those records, the circumstances of how Aquin kept those records, or the accuracy of those records. And again, in the 3 years between 2013 and 2017, I'm sorry, the 5 years at that point, there has been considerable public information about Aquin's servicing practices. We had cited to those in our opposition to the motion for summary judgment on the amended complaint. We cited to those again and asked the court to take judicial notice of those records in our merit brief. Aquin has entered into numerous agreements with various state regulatory authorities and is involved in litigation with the Consumer Financial Protection Bureau that directly relates to the accuracy of their business records. And so our position is that, consistent with prior decisions of this court and consistent with the decision of the 8th District Court of Appeals in Bank of New York versus Rolston, there's a real problem with the accuracy and the reliability of Aquin's records. And there's a real problem with the ability of an employee of SPS to lay a proper foundation under Rule 8036 to incorporate those records, when she has no knowledge of how they were prepared, how they were maintained, and no knowledge of Aquin's systems.
Hasn't this court ruled that a employee of servicer company A can testify about payments, a payment history of servicer B?
I believe so, Your Honor. However, to the extent that the facts in this case are different from prior rulings, we would argue that those rulings don't apply.
You're at 6:19 right now.
I will reserve the remainder of my time.
All right, you'll have 5 minutes.
Thank you.
Good morning, Your Honors, and may it please the Court, Mr. Barrows. My name is Matt Richardson, and I represent Wells Fargo in this appeal. I would submit that it's not deja vu in this case. I think it is different this time. This time we have a final judgment. This time we have a standard of review that is very deferential to the trial court, the abuse of discretion standard of review. Over the borrower's 3 assignments of error, this court should affirm the trial court in every respect. Unlike with prior appeals, the applicable standard of review is abuse of discretion. That means only arbitrary, unconscionable, or unreasonable decision-making can justify reversing the trial court, and that is not what we have here. The appellate court cannot substitute its decision for the trial court under the standard of review. There was no abuse of discretion when the trial court permitted Wells Fargo to join a previously unnamed lien holder to the case to ensure a complete adjudication of all parties to the property. It is a simple, pragmatic decision to join a party under Rule 21. And in this case, it probably would have been an abuse of discretion, more likely an abuse of discretion not to do so.
And there was already a foreclosure.
Right. Pending foreclosure, yes.
That was, no, the foreclosure decree had already been issued.
Yes, but it was not a final judgment.
It was not a final appealable judgment.
Right. And
Is
the
there a
Rule
difference
21,
in your mind?
pardon?
Is there a difference in your mind between a final judgment and a final appealable judgment?
Insofar as Rule 21 permits the trial court to join an additional party at any stage in the proceedings. That's the language of Rule 21. And in this case, I think the fact that we did not have a final judgment makes it extremely likely that that was a correct use of discretion. The alternative would be to adjudicate the case and leave a lien holder having an interest in the property after a sheriff's sale, which I think would be not in the interests of the parties to the action. I think
What
the
would
trial.
happen in that
Pardon?
situation? What would happen in that situation? Because I was trying to figure it out as I was reading the briefs.
Right. In that situation, you have a problem. You have a title problem. And the title problem must be resolved.
Could you dismiss the case and refile?
Yes. Yes, the case could be dismissed and refiled. That would be another option. In fact, if the trial court did not grant the motion to join the additional party, that probably would have been the course of action. There was no final judgment. Under Rule 41, the complaint can be dismissed and refiled and all parties named.
So you're asserting that under 21 it was a mistake, just a simple mistake to miss the Barberton lien holder?
Oh, yes, of course, yes. I mean, I don't think the plaintiff in a foreclosure action intends to leave off a lien holder on the property. The plaintiff in a foreclosure action wants to accomplish the goal of a foreclosure action, which is to transfer the property to a new owner free and clear of all liens. If there is a lien left on the property, that goal obviously has not been accomplished. Nor was it an abuse of discretion when the trial court adjudicated Wells Fargo's amended complaint through a summary judgment proceeding. After the third appeal, it was clear from this court's ruling that the trial court needed to adjudicate the amended complaint. Summary judgment proceedings is precisely how it did it, and that cannot be an abuse of discretion as a result. Nor was there any abuse of discretion in admitting the evidence that Wells produced to support its summary judgment motion.
Counsel,
Yes.
when it comes to the actual granting of summary judgment, we review that de novo.
Yes, but in this case, the third assignment of error is based on an evidentiary objection. In this case, it's not a de novo standard of review because if the evidence is deemed to be admissible, there's no question that Wells discharged its initial burden in moving for summary judgment, and there's no question that the other side failed to produce any evidence to establish a tribal issue of fact. So if the evidence is admissible, then summary judgment is proper.
Well, and I understand your argument, but that doesn't clarify the standard of review, does it? I mean, in other words, I understand your argument in regard to abuse of discretion as to admission of evidence, but the ultimate determination is still de novo review, is it not?
Yes, but it's academic though.
In your opinion?
Well, I can't imagine the basis for reversing under de novo standard of review if all the evidence was admissible to support Wells Fargo's summary judgment motion. I guess that's probably a better way to say it. And I would also submit that amending a complaint under Rule 15, it's under the same abuse of discretion standard of review. That was also designed to accomplish the purpose of making sure that complete adjudication of all parties' interests in the property had been effected. So there was no abuse of discretion in permitting Wells Fargo to amend the complaint and then also to join Barberton Hospital, which was the link holder who had been left off as a defendant on the original complaint. As to the second assignment of error, the complaint was amended to adjudicate Barberton Hospital's interest, and the borrower filed a third appeal. By that point, the amended complaint had not been adjudicated, and this court reversed and remanded so that the amended complaint could be adjudicated. And that's precisely what happened in the trial court after the proceedings were remanded after the third appeal. Not surprisingly, Wells Fargo filed a summary judgment motion to support its amended complaint. And the law of the case doctrine required this result, given the results of the third appeal. And the trial court agreed and gave the borrower more than 6 weeks to file an opposition brief.
What law of the case, but I'm not sure I'm following.
Well, the third appeal, the holding in the third appeal, was that the trial court had not adjudicated the amended complaint. So, upon remand, the trial court was tasked with the duty of adjudicating the amended complaint. And Wells Fargo played a proper role in that by moving for summary judgment. That would be one way to do it, or obviously go to trial.
I understand, but I'm just not understanding what the law of the case was. So the law of the case would be that you adjudicate.
Right.
Oh, okay.
I
I
agree.
misunderstood you. I apologize. I misunderstood you.
And I would say that, to respond to Mr. Behrens' argument regarding the issue of borrowers not having an opportunity to take discovery and defend against a summary judgment motion, 6 weeks elapsed between the date that the summary judgment motion was filed and the date that the trial court permitted leave for the borrower to respond to it. And the borrower did not file a Rule 56F motion. That was clearly an opportunity for the borrower to preserve the issue of fighting for discovery, fighting for the right to discovery.
When would that have been filed?
It would have been filed on or before the deadline to oppose the summary judgment motion.
It didn't know it had an answer that was going to be considered.
I can see that. That's true. At the same time, Wells Fargo agreed to that the answer should be considered when it moved for summary judgment. And the borrower, if the borrower is truly interested, and again, the borrower had not taken any other opportunities to take discovery before this point either. If the borrower was truly interested in discovery, the Rule 56F motion would have been the proper way to do it. And Rule 56F requires a party movement to specify the basis for discovery. And we have not heard anything about what the basis for discovery. We've heard about an abstract need for discovery, but no issues that needed discovery sufficient to oppose a summary judgment motion. So as a result, the trial court could not abuse its discretion in moving on and adjudicating Wells Fargo's summary judgment motion on the amended complaint. Finally, nor did the trial court abuse its discretion in admitting the evidence that Wells Fargo produced to support its summary judgment motion. One basis the borrowers advanced for the trial court's alleged error in admitting the evidence is that the affiant did not testify on the basis of personal knowledge. That is incorrect. Wells' affiant, Diane Weinberger, expressly averred that she was testifying about the borrower's loan on the basis of personal knowledge. She expressly testified as to her job title and job duties. She demonstrated extensive knowledge of the loan and its documentation and the record-keeping systems that kept them and created them. As a result, I don't think there's any question that this affidavit satisfies Rule 56E's requirement of personal knowledge. The borrower is also wrong that any documents from prior servicers were inadmissible, where Ms. Weinberger testified as to all elements of evidentiary Rule 8036 and all elements of the Adoptive Business Records Rule.
Has this court embraced the Adoptive Business Records Rule?
Yes, it has.
It has
in
been
Barth.
across the state that has the ninth.
Yes, the Barth decision, Christiana Trust v. Barth. The Barth decision is, I think, pretty applicable here because one of the things the Barth decision does is it establishes that the only possible piece of evidence that could be considered a hearsay evidence, which is really what we're talking about, it's a hearsay objection, right, would be the payment history. And in this case, the payment history records were from the current servicer, who had employed the affiant who testified to authenticate them. They weren't Auckland's records. There was testimony in the affidavit to indicate that the records from Auckland, the prior servicer, had been boarded into the systems of Select Portfolio Servicing, which is the current servicer. But those records were actually SPS records that she authenticated. So, I think that there's a high level of trustworthiness with these records. It couldn't have possibly have been an abuse of discretion for the trial court to have admitted them. So, as I mentioned earlier, if the evidence is admissible, and it is, and if the trial court did not abuse its discretion in admitting it, which it did not, then there's no dispute that Wells Fargo's initial burden was discharged. And the borrower did not produce summary judgment evidence to attempt to establish a triable issue of fact. As a result, the trial court did not abuse its discretion in admitting the evidence and then ruling on the summary judgment motion in favor of Wells Fargo. As a result, I ask that the court affirm the trial court in every respect. If there are no questions, I will sit down.
Any questions?
Thank you.
Okay, thank you, Attorney Richardson. Attorney Barrier, you have 5 minutes.
Thank you. Your Honor, I think that this case can best be summed up in 2 ways. Number one, the appellee is asking this court to sanction the trial court letting them have their cake and eat it too, in the sense that the initial judgment of foreclosure was not a final appealable order, and they want to be able to rely upon the court striking the answer to the amended complaint and effectively precluding us from participating in the litigation from that moment until the moment the judgment was entered. And then at the same time, not rely upon the evidence that was introduced back at that original judgment. We can't have it both ways. Either the judgment that was rendered against my client initially was a judgment that stands, in which case we don't get into any of the evidentiary issues here, but we have a real problem under Rule 21 on adding a party after the fact, or the fact that the court allowed them to amend the complaint, reallege all of the same issues that were covered in that prior judgment, and then prevent us from participating, creates a real due process problem for my client. Mr. Richardson noted several times that we never attempted to invoke Civil Rule 56F. Let me be clear, that was because we could not. The court had stricken our answer. While we had asked the court and pointed out the injustice of that decision, the court still had not made any determination on whether our answer was in the case or not. And we had to proceed in accordance with that court's order of May of 2015. So to say that we didn't participate and we didn't meet our burden to rebut summary judgment, it's because we weren't permitted to. And ultimately, the abuse of discretion becomes a double-edged sword here, because at every turn in the trial court, we were not the initial counsel for Ms. Russell. We were retained subsequent to the first entry of judgment. Prior counsel had filed a motion to vacate that judgment, which was denied. We filed a motion to vacate that judgment, which was denied. We opposed the motion to add a new party, which was denied. We filed an answer, which was stricken. We lost at every turn in the trial court. And yet at the same time, the trial court is really running the gauntlet here in permitting the plaintiff to amend and add a new party, and then enter judgment in favor of that party and also in favor of us. And I think that's where the abuse of discretion arises. If we're going to be held to a strict standard, then we think that the plaintiff and police should be held to the same strict standard, because this issue only arises from the fact that they missed a defendant from day one. And all of these efforts to correct it after the fact are being done in a way that they want to avoid having to permit our client to engage in meaningful discovery and litigate this case on the merits. Your Honor, unless this court has any questions, I really have nothing further to add. We would ask that this case be remanded. I'm sorry.
He just asked if I had any questions.
We would ask this court to remand this case to the trial court and allow us to conduct discovery and either set the case for trial or allow us to conduct the discovery that we need in order to present a meaningful opposition to summary judgment.
Thank you, Attorney Behrens. Thank you, both of you, for your presentations today. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail you a copy of the decision on the day it's released. And I'll remind you the opinions are also posted on the Supreme Court of Ohio's website. Thank you both again for your presentation.